Ladies and gentlemen, welcome to Irvine Berkeley Theater. We would like to remind you that photography or video recording is not permitted. In consideration of others, all phones and other electronic devices should be turned to silent mode. Also, please take a moment to note the emergency exits in your seating area. Thank you and enjoy the performance.
Good morning, everyone. Thank you so much for joining us for our 9th annual, can you believe it? Our 9th annual UCI Law Supreme Court's term in review. It's truly difficult to believe how much this event has grown in 9 years. I'm sure Erwin will remember that the first event was held in a law school classroom that held about 40 people. And today, we have over 750 people who registered for this event. So this morning, we've brought together some of the best legal minds in the country to discuss the Supreme Court's, I don't think it's an exaggeration to say, blockbuster term, which includes cases involving partisan gerrymandering, abortion, the census, the death penalty, among many others. And I, like all of you, cannot wait to hear this all-star panel's expert analysis. But before we begin, there are a few people that I am compelled, I have to recognize. So first, I have to begin by recognizing our fabulous Chancellor, Howard Gilman. Please. I also must extend a very fond welcome to our founding dean, Erwin Chemerinsky. I made him promise backstage that he would come to every single one of these from now into the future, so. I'd also like to thank all of the special guests of the law school who are here today, and then all of the people who made this event possible, including our own Jillian Henry, our communications team, our development team, the entire team here at the Berkeley, without whom we wouldn't have this event. And finally, I'd like to express my deepest gratitude to Tork Law and Reza Torkzada. We are so appreciative of your generous sponsorship of this event, so thank you very much. So now it's my great pleasure to introduce my extraordinary colleague, Chancellor's Professor of Law and Political Science, Rick Hasen. He's the individual who brings together this remarkable panel, and in a moment he will introduce all of them to you. But of course, Professor Hasen really needs no introduction, so I'll keep this very short. I'm sure many of you read his immensely popular election law blog, or you perhaps have read some of his numerous books, including the most recent one on the late Justice Antonin Scalia. And it's almost impossible to read or listen to the news without coming across some of Professor Hasen's expert commentary. And then I'm sure many of you also saw his recent testimony before the House Judiciary Committee on the subject of foreign interference in our elections. So Professor Hasen represents the very best of what UCI Law has to offer. So please join me in welcoming Professor Hasen and our all-star panel. You are in for a treat.
Good morning. Thank you so much, Song. and thanks to Tork Law for your support for this event. Welcome to Chancellor Gilman. I highly recommend that every university have a leading constitutional scholar as their leader. Very, very helpful. I also want to extend my thanks to Jillian Henry, to Colleen Tarakani, and to the entire large staff of the law school and the Berkeley for making an event of this size possible. This is our annual opportunity for the broader UC Irvine community and the broader Irvine community to come together to talk about a subject of vital importance, the Supreme Court. On behalf of the School of Law, I'd like to welcome you to the 9th Annual Term in Review. Each year, we bring together leading scholars, lawyers, and journalists to consider what the court has done in the past, what it means for the United States, and what it's likely to do in the future. This year's Supreme Court term was an important time of transition, with the replacement of Justice Anthony Kennedy with Justice Brett Kavanaugh after a controversial and bruising confirmation fight. It's the first full term with Neil Gorsuch on the court. This put Chief Justice Roberts as the justice in the middle, and we're going to talk about what that means today. Even as the court decided key issues from partisan gerrymandering to the census, to the death penalty, to the power of the administrative state, it managed to avoid making major pronouncements in other areas. Next term, we could see decisions on DACA, gun rights, abortion, LGBTQ workplace rights, voting rights, and much more. So stay tuned for the 10th annual term in review coming next July. But for this year, we have an all-star cast to sort things out. I'm going to introduce the speakers very briefly so we can get right to the action. Their full biographies are in the events program. Our first panelist, Erwin Chemerinsky, is well known to this audience. Erwin is the Dean and Jesse H. Chopra Distinguished Professor of Law at UC Berkeley School of Law. Prior to assuming this position from 2008 to 2017, he was the founding Dean and Distinguished Professor of Law and Raymond Pryke Professor of First Amendment Law here at UCI. He's one of the nation's leading scholars on constitutional law and so much more. Sarah Harrington is a partner at Goldstein and Russell, PC. Sarah joined the firm after finishing an 8-year run as assistant to the Solicitor General at the United States Department of Justice. In that capacity, Sarah argued 20 cases in front of the United States Supreme Court and wrote merits briefs in more than a dozen additional cases. Earlier in her career, she worked as an appellate attorney in the Civil Rights Division at the Department of Justice, where she handled dozens of appeals on behalf of the government. Chris Geidner is Senior Advisor for Law and Policy at the Justice Collaborative, a research and advocacy organization that works to reduce incarceration and otherwise bring human dignity and restraint to our flawed criminal justice system. He spent the past decade working as a journalist in Washington, D.C., most recently covering the Supreme Court and national legal affairs as legal editor at BuzzFeed News. Prior to moving to D.C., he was a practicing lawyer in Ohio, and while in law school, he was editor of the Ohio State Law Journal, where I had the great pleasure of having an article on the Voting Rights Act edited by Chris when he was a student. Michele Goodwin is Chancellor's Professor at the University of California, Irvine, and founding director of the Center for Biotechnology and Global Health Policy. She's on the faculty of the Stem Cell Research Center, Gender and Sexuality Studies Department, Program in Public Health, and Department of Criminology, Law, and Society. She's an elected member of the American Law Institute, as well as an elected fellow of the American Bar Foundation and the Hastings Center. And Jonathan Adler is the inaugural Johan, I should have asked you, Verheij Memorial Professor of Law and Director of the Coleman P. Burke Center for Environmental Law at the Case Western Reserve University School of Law, where he teaches courses in environmental, administrative, and constitutional law. Professor Adler is the author and editor of 7 books, over a dozen book chapters, and many articles and op-eds. The plan for the day is as follows. Each panelist will speak for 7 to 8 minutes about one of the court's cases this term, as well as a theme of the term. I will then turn to questions and conversation among the panelists. I will ask the questions, including those that you can fill out if you're in the audience, on note cards that have been handed out to you and that will be collected a little bit later. If you're watching online, you can submit your questions via Twitter using the hashtag UCI Law SCOTUS, all one word, UCI Law SCOTUS. Please keep your questions brief, and please keep them questions. And with that, I'm going to turn it over to start with our good friend, Erwin.
Thank you. It's truly great to be back at UCI. Today's program and this whole series was created by Rick, and I want to congratulate him on this, express appreciation for it, and thank you for including me again. It was an unusual term of the court. I thought I'd offer a couple of observations about it overall, and then I want to talk about the partisan gerrymandering cases. First, you should think about the term. The justices were as divided as ever, but less ideologically split. This year, there were 67 cases decided with signed opinions after briefing and oral argument. 21 of them were resolved 5-4. It's about the same as last year. Then there were 59 cases decided after briefing and oral argument, and 19 were resolved 5-4. But last year, the conservatives prevailed in almost every major case. Of the 19 5-4 decisions a term ago, in 14 of them, the majority was Chief Justice Roberts, and Justice Kennedy, Thomas, Alito, and Gorsuch. This term, out of the 21 5-4 decisions, the 5 conservative justices were together in the majority in slightly less than half. In fact, there were 4 cases where Justice Gorsuch joined together with Justice Ginsburg, Brierson, and Kagan to create the majority in a 5-4 ruling. Now, it's hard to know whether it's a reflection of what was on the docket this term or is something that we're likely to see in the future. As you reflect on that, I'd make a second observation, and I think that this term, the justices, whenever possible, trying to stay away from the hardest and most divisive issues. On Friday, January 11th, the justices met in their private conference to take the remaining of the cases to be heard this term. They had 8 slots open on their April oral argument calendar. They had an amazing array of cases to choose among. They had a Ninth Circuit opinion that upheld a preliminary injunction against President Trump rescinding the deferred action for child arrivals at the DACA program. They had a Second Circuit opinion that upheld a New York City ordinance restricting having guns outside the home. They had a Seventh Circuit opinion striking down an Indiana law imposing significant restrictions with regard to abortion. They had a split among the circuits as to whether sexual orientation discrimination in employment is a form of sex discrimination that violates Title VII. They had 3 cases where federal district courts had issued preliminary injunctions against President Trump's ban on transgender individuals serving in the military, and the Justice Department was asking for expedited review. The case of the New Jersey Supreme Court that had said that local governments could not give money to churches for historic preservation. Do you know how many of these cases the Supreme Court took to hear this term? None of them. And I don't think it's a coincidence. I think after the bruising Kavanaugh hearings, the justices were consciously choosing to keep a lower profile. Now, of course, they've taken many of these cases for next term, as Rick mentioned. There are always unintended consequence decisions. And I think here are the unintended consequences. These cases will be decided next spring in the midst of the presidential primaries and the election season. So I don't think the court's going to succeed in the long term in a lower profile. But it does mean that this term, there were fewer blockbuster cases than usual. In fact, the most high-profile cases were ones that the court felt it had to take. The census case that we'll hear about in a moment was an instance where the court took it even without a court of appeals decision because of the time pressure, the government saying it absolutely had to have the census forms printed by June 30th. And the cases I want to talk about involving partisan gerrymandering, they were decided by 3-judge federal district courts. And when that unusual procedure happens, the Supreme Court is obligated to take and decide the matters. So as to the partisan gerrymandering cases, partisan gerrymandering, of course, is the practice where the political party that controls the legislature draws election districts to maximize, say, seats for that party. It's where, say, a Republican-controlled state legislature draws congressional districts to maximize, say, seats for Republicans, or a Democratic-controlled state legislature draws state legislative districts to maximize seats for Democrats. The practice is nothing new. It takes its name from a governor of Massachusetts early in American history, Elbridge Gerry, who did exactly that. But what's changed is, because of sophisticated computer programs, because of mass data collection, it's now possible to engage in partisan gerrymandering with far more precision than ever before. The Supreme Court had 2 cases about partisan gerrymandering this term, though they issued only 1 opinion. One of the cases was Rucho versus Common Cause. It comes from North Carolina. North Carolina is basically a purple state. It voted for Obama in 2008, for Romney in 2012, for Trump in 2016, but always by 51, 49, 52, 48 margins. Republicans got a slight majority of the votes cast for the North Carolina legislature, then drew legislative districts to give themselves supermajorities in both houses in North Carolina. They then set out to draw congressional districts. And in a written report, they said they wanted to try to give themselves control of 10 of 13 seats in the House of Representatives in North Carolina. The report was candid. It said they would try for more if only they could find a map to do so. They succeeded. In the 2016 election, Democrats and Republicans got the same number of votes in North Carolina for Congress, but Republicans ended with 10 of 13 seats. The other case came from Maryland. It involved a Democratic-controlled state legislature drawing districts of the House of Representatives to create an additional Democratic seat. 3-judge federal district courts found both of these to be unconstitutional. For North Carolina, the district court focused on equal protection. For Maryland, it focused on the First Amendment and discrimination on the basis of political party affiliation. On Thursday, June 27th, the Supreme Court, in a 5-4 ruling, held that challenges to partisan gerrymandering are non-justiciable political questions. Put simply, federal courts no longer can hear such challenges. Chief Justice Roberts wrote for the conservative majority. He said, "A matter is a non-justiciable political question if there are no judicially discoverable or manageable standards." He said, "There aren't standards here." He said, "We have no way of knowing what's too much when it comes to gerrymandering." He said, "This is left to the political process. Congress, if it wants, can regulate how districts are drawn for the House of Representatives. States can create independent districting commissions. Additionally, states can find this violates state constitutions, as Pennsylvania did a year ago." Justice Kagan wrote a blistering dissent. She said, "Partisan gerrymandering is inconsistent with our democratic process. It's supposed to be voters who choose elected officials. Partisan gerrymandering means elected officials are choosing their voters." She said, "We can create standards as we have in other areas. In the area of race, if a predominant factor in districting is race, it's impermissible unless strict scrutiny is met." She says, "Likewise here, we should just focus on purpose, effect, causation, like in so many other areas of law." She said, "We can't rely on the political process here. Those who benefit from gerrymandering aren't going to alter the practice to vote themselves out of office." She ended her opinion in a way I've never seen a justice conclude, even a dissent. She said at the end, "Sadly, I dissent."
Sarah?
All right, I'm very happy to be here. I'm a California native, but this is my first time on the UCI campus, and so
welcome.
Yeah, thank you. Thank you for inviting me. It's really fun to be here with this group. So I'm going to talk about the census case, and I should give a disclaimer that the information I have is current only up to when I left my phone back in the green room and came on stage. Because it is a breaking news case even after this decision has come out. And so, the theme I want to touch on, and I'll just touch on it briefly because there's a lot to talk about the census case, is the relationship between the Department of Justice and the court. And I was a DOJ lawyer for 17 years, so this is a topic that's very close to my heart. So the relationship is supposed to be the Department of Justice, the executive branch, it does the litigation for the executive branch before the court. There's a person called the Solicitor General who's in charge of all the Supreme Court litigation for the entire federal government, is a frequent litigator. The SG is often referred to as the 10th Justice, and that is, I think that designation is meant to convey that the SG is viewed by the court as a very credible person and office, and is there to sort of give the government's best view of what the law should be, even when the best view isn't necessarily in the absolute best interest of the government. The SG's office is viewed, because it's a repeat player, as having sort of a special, it's the most repeat player that there is, sort of a special place in its relationship with the Supreme Court. But the two are distinct and separate institutions. In this last couple of years in this administration, the president in particular has started to express a sense that the Supreme Court is kind of in the pocket of the administration, that it has a real home court advantage there. So he has often made statements or tweeted statements saying, when something the government does is challenged and the government loses in the district court, saying like, "Oh, it's fine, the Supreme Court's going to fix it for us," basically conveying that sense. Many people have commented on this, and I think what it does is it puts a lot of pressure on the court and in particular on the Chief Justice. Chief Justice Roberts, it's very important to him how the public views the court and that they view it as a legitimate institution, an independent institution. And so the sense in DC, in the Supreme Court bar at least, is that he has not been that happy with the president's portrayal of the relationship between the administration and the court, and that he has felt some pressure to really show that it is an independent and fair and impartial institution. And so that brings us to the census case, and the census case is an example of something that we've seen from this administration, which is that they have taken advantage of sort of extraordinary procedural mechanisms to get issues to the Supreme Court. And so normally, probably all of you know this, there's a trial in a federal district court, there's an appeal to the Court of Appeals, and then you ask the Supreme Court to review the Court of Appeals decision, and almost always they say no, but sometimes they say yes. So there have been several instances where the SG's office has just tried to skip over the Court of Appeals, or has, while a case was pending in the Court of Appeals, asked the Supreme Court to come in and intervene, or even while a case was pending in the district court. And those are really extraordinary and should be very unusual moves, but we've seen a lot of them in the last couple of years. And to be fair to them, to give equal time, or maybe not equal time, but to give some time, they would say, well, there's been a lot of nationwide injunctions against us, and so these are really important issues, and we need the Supreme Court's help. But so the census case is an example of that, and so I'll try to stay within my time. There's a lot to say about the census case, but the census case starts with the well-known enumeration clause of the Constitution. I know you're all familiar with that one. And that directs Congress to take an actual enumeration of the population of the country every 10 years. And Congress has delegated that authority to the Department of Commerce and the Census Bureau, which is in the department. And so that duty has fallen to Wilbur Ross, who's the Secretary of Commerce. And he, in March of 2018, so just a little over a year ago, he issued a decision memo saying, we are going to add back to the household questionnaire that is sent out a question about whether the people who are answering are citizens, or whether members of the household are citizens of the US. And just to give a very brief history of this type of question has been included in some form or another on some of the census questionnaires that have gone out for going back to the beginning of the country. But for the last, I think it's 70 years, it has not been included on the main questionnaire that has gone to all households. It has been included on, off and on other questionnaires that have gone to only a smaller subsection of the population. And the reason that the question was taken off the main questionnaire form was that people determined within the Census Bureau that it resulted in a less accurate count. So the point of the census is to get an accurate population count, including this question resulted in a less accurate count because it made certain populations, namely households that included people who were not in the country, who were not citizens, and also just Latino households who even if they are citizens, it made them respond less quickly. I have 3 minutes, come on. So let me fast forward a little bit. So he said, we're gonna include this question. He was immediately sued. The administrative record, which is sort of gives the agency's decision and the reasons for it, was not very complete. They supplemented the record. The original reason that Wilbur Ross gave was, he said, well, the Civil Rights Division of DOJ has asked me to include this question because they need it to better enforce the Voting Rights Act. So turns out not to be true. Shocking. So then it turns out that evidence comes to light that in fact, when Wilbur Ross became the secretary, he had the intention of including the question from the beginning, that in fact the Department of Commerce solicited the question, first from DOJ, then from DHS. Neither of them was willing to do it. Then he called Jeff Sessions personally, who was then the Attorney General, and said, could you please ask us to include this question? And so eventually DOJ complied. So they're sued in the district court in New York. The plaintiffs prevail. There's various theories, which I won't have time to go into, but the plaintiffs prevail, and the Department of Commerce is enjoined from including the question. And so then DOJ says, well, we have to go right to the Supreme Court because we have a very hard deadline. We have to finalize the questionnaire by June 30th of this year, so 8 days ago, or we're not going to be able to print the census in time without additional appropriations. So the Supreme Court says, fine, you can come straight to us. So the case goes up, various questions are added, there are all these procedural strange things that happen, but it's all about getting it done by June 30th. The argument happens, most people think the argument goes very well for the government, that the court is gonna sort of do what it did in the travel ban case, which is say, we look at the official reason given in the record, if that seems like a rational enough reason, we kind of ignore the noise. But at the beginning of June, strange things happen. In a separate case in North Carolina, their evidence comes to light. There was a Republican redistricting strategist. I'm going to go over, I'm sorry.
Does that work for you with the Supreme Court?
No. Mr. Chief Justice, may I extend my time? I'm coming to the good part. So the Republican redistricting strategist who dies, and his estranged daughter gets his hard drives. It's like, you couldn't write this better than it happened. And there are memos in there saying, hey, Republicans should add the citizenship question to the census because doing so would be advantageous to, in his words, Republicans and non-Hispanic whites. And he has like a whole memo or article in there, much of which looks a lot like the letter that DOJ sent to Commerce. And then it sort of comes to light that there were meetings that were orchestrated between this guy and DOJ, orchestrated by Commerce. And so the plaintiffs in the case, in the Supreme Court case, they go to the court and they say, hey, could you please remand? Because we need to do some fact-finding and find out what's going on, because now it looks like there's like a racially discriminatory motive behind this, I know. And the DOJ says, no, you can't remand, June 30th. So anyway, ultimately, the Supreme Court issues a decision, and what they say is basically, the Census Bureau has the authority to include this question, but they have to give a real reason for doing so, and this was not a real reason, this was pretext. And so that's the Chief Justice and the 4 liberal justices over blistering dissents from the more conservative justices. The liberals say, we don't think you have the authority to do it, but they agree that there's pretext. And so the chief basically says, if you can come up with a real reason, or a better reason, a reason that doesn't look like a lie, then you can do it. And he doesn't say lie. His language is like, he says, it does not match with the rationale, or there's a disconnect, it's contrived. He's very gentle in the way he says you're lying. And so everyone thinks, so that happens on June 27th. Everyone thinks, well, there's 3 days till June 30th, so that's the end of it. And in fact, on July 2nd, the DOJ says to the plaintiffs in the case, we're done, we've lost, it's over. And then the president starts tweeting. He says, this is fake news, we're not giving up. And so then there are various court proceedings where the political appointees come in and say, well, we've been instructed to try to find a way to do it. And the 2 judges in the different cases are like, what about this whole June 30th thing? Well, we're trying to figure it out, And so that's kind of ongoing. The government has been instructed to try to find a way to include the question. Unclear how they're going to manage their repeated statements from the Solicitor General to the Supreme Court that June 30th was a hard deadline. The latest news, and then I'm done, is that last night it came to light that the legal team that's been on this case from the beginning at the DOJ has now been taken off the case, and a new legal team from the Consumer Protection Bureau, which doesn't have subject matter expertise in anything having to do with this, has been put on the case. No reason was given. I think one can assume that the lawyers who've been on the case said, I think we're going to just do something different now. We don't want to be involved in what's going to happen. So I'm sure there's going to be more that happens in the next couple of days, so stay tuned.
Thank you.
Well done. That was like a speed. Hi, all. Thanks a lot for keeping me on the panel, even when I left journalism. And so while I do have a decade of experience covering the court and stuff, so you all know I do advocate now for criminal justice reform, so keep that in mind. But I try, something that I always said when I covered the court, and I covered LGBT issues before that, and I'm a gay man, and people would ask me about bias, and my answer was like, if I think something's right, then if I tell you the facts, eventually you should be won over to it. And so I sort of now am on the other side of that role, and I have the same view. And so I'm going to go through what happened, and I think sort of on the larger point of where the court's at, I think one of the most interesting things that I saw from this term is that basically anybody now has the power to be Justice Kennedy on a given case because of the fact that we have this 5-4 split. And I think we've seen, particularly for the chief for a while, and that's what we were all talking about when Justice Kennedy retired, but also with Justice Gorsuch and even on a couple of occasions with Justice Kavanaugh, this idea that at any given moment, these justices have the ability now, if they're in the center, to be the swing vote. And we even saw one case, I think, where that flipped, where Justice Breyer became the fifth vote for the conservatives when Justice Gorsuch didn't. And so I do think that that's something that, particularly when we get into the stuff that Erwin was talking about, when we get away from some of the cases that they heard this term and into the cases that are more obviously partisan and ideological, it'll be interesting to see if that holds. But it is a lot of power that these justices have with the current split, and that's definitely the thing that I'm going to be looking at going forward. And I think we saw that as well on the death penalty, particularly this term, because we basically we have 4 different areas. And so I'm going to sort of cheat. And I told Rick ahead of time, and he didn't tell me no. So looking at what we had at the court, they're sort of in the lead up to Justice Kennedy's retirement, there was this hope among some advocates that some of the things Justice Kennedy had done in the past were leading to a position where he eventually could be won over to eliminate the death penalty. Obviously, we didn't reach that point before he retired. And when Justice Kavanaugh came on the court, there is sort of at this point this standstill on broad Eighth Amendment litigation. None of the cases that raised those issues were granted, and it seems unlikely that the court would take that up anytime in the near future. But I would also say we don't quite know where Justice Kavanaugh will be on that. We have some assumptions, we have some ideas, but we don't have a lot of writing about that. We don't have a lot that he even talked about this term. And so I think that it will be interesting to see when he is faced with actually talking about those issues, how he addresses that. We did get some really strong signs that Justice Gorsuch will be as strong of a pro-death penalty vote as there is on the court currently. Then you get into the second area, which is method of execution challenges. And that was the case of Russell Bucklew earlier this term. And it is clear that there was this period over the past decade, basically, of the court, first in Bays and then in Glossop, sort of pulling back how much you can challenge the method of execution that a state is choosing to implement. Those often, Justice Alito famously sort of pressed back against those claims as the result of guerrilla warfare by opponents of the death penalty to restrict the ability to import certain execution drugs, to manufacture those drugs. People trying to, Texas and other states, who have tried to import the drugs from overseas. And basically in Bucklew, the court pulled method of execution challenges basically back into effectively meaninglessness, because you need, at this point, in order to challenge a method of execution, you not only need to provide an alternative means of execution, but that even applies if you are making an as-applied challenge that you're saying, because of my particular medical condition or whatever, if I would experience extreme pain by this method of execution, you still need to maintain and provide an alternative means of execution. And so at that point, the idea of a method of execution challenge really being able to lead to any real delay is almost gone. The court, in some of the public fighting this term, was over requests to issue stays of execution. And it's clear that anything that comes up last minute at this point before the justices, they're going to, the 5-4 majority, the ideological conservative majority, is going to be exceptionally skeptical of those claims. But in that slight bit of sunlight, and part of the reason why there is questions is that there was one case after the court did not allow a stay of execution for Dominique Ray, the court then allowed a stay of execution for Patrick Murphy. And it came down to Chief Justice Roberts and Justice Kavanaugh. And it really was a question about the timing. And they said, basically, this claim came to the court as soon as they knew that they could bring the claim for Murphy, whereas they felt that the claim by Ray's lawyers was truly an attempt just to delay. And so there is this bit of sunlight that if you have a real claim that you want to bring, an equal protection claim, in these cases it had to do with chaplains being present, that you could bring it. The one I'll go over a little bit as well.
You set a precedent, Sarah.
Yeah,
I'm fine with it.
that's the way the law works.
Except with this court.
Except with this court, yeah. Precedent means not much unless it does. The one area where there do appear to still be sunlight for movement is when there are established rights that the court has already established, and there are basically states that are doing bad. When you can really show that either in the case of Texas, they're not taking seriously the court's rulings on intellectual disability, making somebody ineligible for the death penalty. And in that case, it was Bobby James Moore's case, who came back to the court after the court already tossed it out once, came back up, and this time even the Chief Justice flipped sides and said, basically, I didn't agree with this last time, but we said it, and you're still not doing it. And then in the case of jury selection, there was a successful Batson claim brought by Curtis Flowers, who had 6 trials, and all but one of the black jurors had been struck by the prosecutor. And in that case, you even got Justice Alito to side with a criminal defendant. And when you've reached that point in a case, you really need to think twice about what you're doing. And there also was but that's more seriously, that was an opinion by Justice Kavanaugh. Now, the majority opinion was by Justice Kavanaugh, and it really did delve into this right matters. There's a reason why we have Batson, this idea that you cannot be discriminated against in jury selection. And when a prosecutor's office, when a state really shows us that they're not taking this seriously, we will look at it. And the other area was with competency to be executed, and that was Vernon Madison's case. And that was a similar sort of situation where the court said, well, we had talked about this type of competency previously, but particularly as we deal with aging populations, there are people who are reaching a point that they do not understand why they're being executed, and the court made it clear that they will look at those claims. I have another thing, but I'll save it for questions. But it's about Justice Thomas in an area where he sort of misrepresented a prior case. So I'll bring it up.
Okay, so in following the precedent that Rick has established in prior times, it's a pleasure to see you all. So welcome Orange County and welcome UCI to this. So Rick asked us to speak about a theme and then a case. I'll be speaking about an abortion case, Box v. Planned Parenthood. But before I do that, I want to speak about themes that I saw emerge over this term. And one of those actually deals with the question of stare decisis, and that is precedent and the value of it. And we see the slippage of it, or one could call the gerrymandering of precedent. Precedent matters when there are justices on the court that believe that it matters and that otherwise it just simply doesn't matter at all. And you see that emerging particularly within the area of abortion. And one of the issues that I want to raise there is to pick a nuanced point, because those on the left have spotted this as a real problem. But I think it's important to actually dig in a more nuanced way, because there are actually times in which precedent should be disturbed. And if we don't add that to the conversation, then there's something that we're missing. So you might wonder, well, when are the instances in which precedent should be disturbed? Well, if we look at the history of the court itself, there are times in which the court has not lived up to the value of our Constitution and constitutional principles, particularly in issues involving race, involving sex, et cetera. So if you think about Dred Scott, Plessy v. Ferguson. Plessy gets overturned with Brown v. Board of Education. We should be happy about the strike of that precedent. Or if you think about a case, Buck v. Bell, which engineers and brings in eugenics in the United States, the law that's upheld by the Supreme Court in 1927 ends up serving as the foundation for the laws that's used in Germany with its eugenics platform. So when we think about precedent, it's important to think about it in a more nuanced type of way, even within the context of what's happening in this court. The second thing that I think is important to think about with regard to this term and what we may see in the future has to do with what's going to happen with regard to reproductive health rights and justice. And that is to say, there's a question as to whether Roe will be overturned with one swift kick. And I think not. I think it's really a death by 1,000 strikes. And I think it's a lot of litigating that's being proposed or that's happening at the state level. Some say, well, this is just to wear out those who happen to be reproductive health proponents. That is, one thing that's very interesting is the re-litigating of matters that the court has already settled. So 2 years ago in Whole Women's Health, the Supreme Court struck down two Texas laws, one that involved admitting privileges of doctors, and the other that involved ambulatory surgical requirements of clinics. Supreme Court struck those down, and based on an empirical record that those laws did pose a substantial undue burden to women. But you see these same, virtually the same laws cropping up again in states. In Minnesota, virtually the same two laws came up, and you see this in other cases that are going to come before the Supreme Court. One final theme that I want to touch on, and there are many others, is the rise of Clarence Thomas. Now, Rick, I hope that I can say this. When I took my daughter to hear, well, I guess I'm going to say it, right? So when I took my daughter to hear arguments in the Supreme Court when she was 9, she's 24 now, and she said, "Mommy, why is it that the black justice looks like he's asleep and doesn't ask any questions?" Really, this is what she said. Really, that's okay, Rick? Okay. All right. Well, you see now that Justice Thomas has awakened. And one of the areas in which he's decided to be awake, I won't call it woke, happens to be within the context of abortion, which then gets us to Box v. Planned Parenthood. Okay, that's good. I can do this in 3 minutes. All right, and that's a case where the Supreme Court takes up a case from the Seventh Circuit where they struck down invalidated Indiana laws that, one, was a law that dealt with the disposition of fetal remains. And the context of the law was that fetal remains could not be disposed of with the other kinds of surgical elements from the abortion itself, even though simultaneously a woman could decide for the cremation of the fetus. The second part of the law, which is the part where Thomas comes awake, deals, and it's the part that the Supreme Court doesn't address, is this question about race, sex, and disability with relation to abortion. And that is, the state of Indiana said that it would be illegal for an individual to have an abortion, and the focus of that abortion being race, sex, or disability. Thomas takes up that point, and one could argue that he does so disingenuously. He roots it all in eugenics, and he sounds alarm about the fact that really what we're doing is entering an era of eugenics, and that technology is helping us to engineer eugenics with abortion. Abortion, he's suggesting, is now a slippery slope, or could become very soon a slippery slope of eugenics in the United States. Now, there are many reasons to take apart Justice Thomas's concurrence in this particular case. It actually reads as if it would be quite good for a law review essay, perhaps more so than a concurrence in this particular case. He suggests that there is no respect, thank you, for, and I'm going to follow that 1 minute, I hope so. Basically what you see is Justice Thomas doing something very important, and it's a very important linguistic turn that you see not only in this case, but also in the Harris v. Alabama case. And the linguistic turn that really is important to watch is that he uses the term of child to refer to fetuses. He's moved beyond the unborn child, and now this is children, and it's state subjecting children to eugenics and subjecting children to dismemberment. And in respect for your time, Rick, I'm going to end there and save the rest for Q&A.
Thank you.
Alrighty. Thank you, and it's a pleasure to be here. Rick's tried to get me out here a few times, and I'm glad I was finally able to make it. What I want to try and talk about briefly and try to make interesting is administrative law and the court's term. I know from talking to my wife and daughters that trying to get an audience interested in administrative law is often very difficult, but I'm going to try and explain to you why this should interest you and is important, and particularly important for this term and for the court as it's currently constituted. And then I want to say a little bit about precedent and stare decisis, because there's a relationship between what the court might be trying to do in the context of administrative law and precedent. But why is administrative law important? Well, administrative law is basically the set of rules that the government has to follow before it wants to tell you what to do, take something from you, and in some cases give you something. The census case is in many respects an administrative law case. If the Food and Drug Administration or the National Labor Relations Board or the Securities and Exchange Commission or any one of the myriad federal agencies is implementing a program or changing a program or creating rules for private conduct, administrative law is the substance of the various things they have to do. And those rules really matter, right? They affect whether or not a given agency can do the things it wants to do, whether or not the federal government can implement or rescind an immigration program, an environmental program, and what have you. So it's very important, even though it often gets very technical and very complicated very quickly. It's also something worth watching now, because I think it's pretty clear that administrative law was one of the primary issues that the Trump administration has been concerned about in making judicial appointments. Many people have suggested that Justice Gorsuch's opinions as a lower court judge relating to administrative law questions were part of what caught the attention of the White House counsel's office. And there's no question that Brett Kavanaugh's long service on the U.S. Court of Appeals for the D.C. Circuit, which has a very administrative law heavy docket, was one of the things that made him an appealing Supreme Court nominee. And so seeing what happens with administrative law on the current court is important because that's part of why some of the justices are there. Now, this term, we had a lot of administrative law cases. You heard already about the census case. I want to talk briefly about two that are of particular importance. The first of those cases is a case called Kaiser versus Wilkie. And it's a run-of-the-mill case. It's about this guy who wants veterans' disability benefits, and he claims that he was entitled to veterans' disability benefits many years before the Department of Veteran Affairs thought he was entitled to benefits. And the key issue in this case, and it gets the procedural issues are complicated, is whether or not the Department of Veteran Affairs' interpretation of the word relevant in its own regulations has to be followed by the courts. Basically, the issue is whether or not some documents related to Mr. Kaiser's service record were relevant to his disability claim. He thought they were. The Department of Veteran Affairs said no. The regulation wasn't self-evidently clear on that point. And so the lower court said, gosh, we don't know. It's ambiguous. Agency wins. The agency gets to tell us, the courts, what an ambiguous regulation means, provided they've given us a reasonable interpretation. And Kaiser made the argument that, well, that's unfair. That is like the agency getting to put its thumb on the scales in a dispute. The agency wrote the regulation. In a lot of other legal contexts, we construe legal documents against the interests of the drafter. In this case, we are essentially saying the drafter gets the benefit of the doubt. And I should note, just disclosure, I did file an amicus brief in this case on Mr. Kaiser's side. The Supreme Court accepted this case on the question of whether or not to overturn a precedent called Auer versus Robbins, which was the source of this rule that when a regulation is ambiguous, the agency that wrote the regulation should be deferred to by a court, provided the agency has offered a reasonable interpretation of that. The court unanimously held that the lower court had been too quick to adopt the agency's interpretation. But 5 of the justices, in an opinion by Justice Kagan, said, we're not overturning this rule. We are rather clarifying, some would argue tightening, this rule, setting forth various conditions that an agency must meet before it gets deference. But this underlying rule that there are situations in which courts should defer to an agency's reasonable interpretation of its own regulation will be upheld. It has long-standing roots going back decades, Justice Kagan said, and we should leave that alone. And she was joined by the other liberal justices and by Chief Justice Roberts. Justice Gorsuch wrote an opinion concurring in the judgment saying, this is unfair. It contravenes separation of powers principles because the entity that is writing the rule is also, and enforcing the rule, is also the entity interpreting the rule. And that's the sort of situation that our separation of powers structure is designed to avoid. And he argued, while it's certainly true that in a lot of areas, an agency is going to have a degree of technical expertise that is worthy of the court's respect and that courts shouldn't ignore, this deference rule should be gotten rid of, and that it had no foundation to begin with and should be overturned. What's really interesting is that Chief Justice Roberts, while joining Justice Kagan's opinion, writes separately to say, in practice, the gap between Justice Kagan's opinion and Justice Gorsuch's opinion isn't that great. Because Justice Kagan says we have this deference rule, but there are a whole bunch of qualifications and conditions. And Justice Gorsuch says, no deference rule, but you can't close your eyes to the fact that agencies often know a lot more about the details of a program than a court does. And to illustrate this, don't think about the Department of Veteran Affairs and the meaning of the word relevant. Think about the Environmental Protection Agency or the Food and Drug Administration dealing with a complex issue that involves the intersection of law and science and technology, where clearly the agency is going to know a lot more about what's going on than a generalist judge who doesn't hear these cases on a routine basis. So this is a very important case because it affects the rules of the road for those that are having to comply with agencies, narrows a precedent, doesn't overturn it. I see I have 1 minute, and I'm trying to respect the new precedent that has been established. I've saved it in time. There's something similar that occurred in a case called Gundy. Super quick, Gundy involved something called the delegation doctrine, or some prefer the non-delegation doctrine, and it's the set of rules that govern under what conditions can Congress give to an agency the power to draft rules that then apply to private conduct. And for the last several decades, the court has said, we're really not comfortable deciding when a delegation goes too far. We've only found that Congress did that twice, both in 1935. We haven't done it since. Basically, if Congress is willing to give its power away to agencies, to the executive branch, then Congress can do that, and Congress can use oversight to police that. The Gundy case challenged that because it arose not in the sort of context we usually think of in administrative law. Here was a guy who was a convicted sex offender. Okay, I'm going to break that precedent. And he had served.
You see how slippery it is.
He served his 5-year term, after he had been convicted for his sex offense, Congress passed a new law requiring that sex offenders register. And he didn't register. And part of the reason was, well, this law had been enacted after his offense. Well, that law also said that failure to register is itself a separate offense. And so this guy, Mr. Gundy, who served a 5-year term, was going to be convicted of a 10-year sentence for failing to register. And the basis for that was that Congress had given the power to the Attorney General to decide whether and under what conditions this new registration requirement applied to individuals whose offenses predated the enactment of the federal law. And so Gundy's argument was you can't give the Attorney General that power, especially without any guidelines about how that power is to be used. The court rejected his claim, 5-3. And Justice Kagan again wrote the opinion, saying that, well, it may look like the Attorney General was given this broad power, but actually he was given very little power. The power he was given was to decide how quickly or how feasible it was to apply this requirement to previous offenders. And understood that way, this isn't a big delegation. And so we don't have to raise any serious questions about how much is too far. Justice Gorsuch again dissented. You see a pattern here, saying that this doctrine had to be revised, and this was a particularly egregious case. In both these two cases, the court avoided overturning precedent. In one case by arguably rewriting the prior precedent and narrowing it, and the other by arguably rewriting the statute to make the statute seem less offensive or less aggressive in the way it applies. And this is something I think we've seen on the Roberts Court a lot. The last point is when we talk about precedent, the court overturned 2 precedents this term. It was asked to overturn several others that it did not overturn, not just the ones I mentioned, also double jeopardy precedent. And this is actually a pattern we've seen in the Roberts Court. Since Chief Justice Roberts has been the chief, the court has overturned precedents at a substantially lower rate than the Rehnquist Court, than the Berger Court, or than the Warren Court. That past performance is no guarantee of future results. That obviously can change going forward. But at least up until now, in its first 14 years, this court, whether it's overturning the right precedents or the wrong ones, has been doing so far less than its predecessors. And this is true under multiple different data sets that one can look at. And so that's interesting. So there's a lot of discussion about precedent. I think we agree that abortion is part of the reason that's the precedent that a lot of people are shadowboxing over. But across the full range of cases, precedent has been being upheld more frequently than it has in the recent past.
Thank you. All right. If you're in the audience and you have a question on a card, you can pass them to the aisles and they're going to be collected. I will implore the panelists to keep your responses brief so that we can discuss a number of issues. I'm going to start with a question on Twitter. This is for Erwin or anyone, but it relates to the Rucho case. Will the justices who cited independent redistricting commissions as a justification for doing nothing to police partisan gerrymanders in Rucho turn around and vote to strike down commissions next term? Sincerely, angry Common Cause plaintiffs.
In 2015, the Supreme Court decided a case called Arizona State Legislature versus Arizona Districting Commission. And the issue was whether or not voters in a state can pass an initiative to create an independent commission with regard to House of Representatives districts. And the Supreme Court 5-4 said that such independent districts are permissible. Justice Ginsburg wrote for the court. Justice Kennedy, joined by Justices Breyer, Sotomayor, and Kagan, were also in the majority. Chief Justice Roberts wrote a vehement dissent, joined by 3 other conservative justices. So there is an irony given Chief Justice Roberts believing that independent commissions are unconstitutional when created by initiative, now saying, oh, independent commissions are an alternative, so we don't need to worry so much about federal courts not being able to hear challenges to partisan gerrymandering. Justice Kennedy is no longer there. Might the court now reconsider that case? It's possible.
All right, on that ominous note.
That was succinct.
Yes. Yeah. So for a long time, as Erwin mentioned, the court sat on the petitions involving the DACA case. At the end of the term, the court agreed to hear the case, and now, just this morning, it put it on the fast track for arguments. It's going to be heard November 12th or November 11th. What's going on? What's likely to happen? What should we be watching for? And this, we can work our way down.
Sure. What's going on, I think the court realized that in terms of, once it was clear they weren't going to take the DACA cases for this term, the difference between accepting certiorari in February and accepting in June really doesn't make much difference in terms of how quickly they hear it in the fall. And I think this morning's order confirms that. I think the court was hoping that either Congress or the administration might make the cases go away. And given that there are multiple cases involving DACA, certainly thought there might be a benefit of seeing more cases decide this. On the substance, I actually think the DACA case shouldn't be that difficult a case. Under traditional administrative law principles, the administration should win that case. We've already seen, and the census case may be an example of this, and there are plenty of examples of this in the lower courts, of the administration losing cases it should be able to win under traditional administrative law principles because it doesn't do the work. As I tell my students, administrative law demands a lot of government attorneys, and you've got to work the processes appropriately. You have to dot your I's and cross your T's, and if you don't, you should expect to lose. And there are quite a few cases in the lower courts where we see the administration, and this is an administration that has suggested that it doesn't need the expertise that people typically think the government needs, doesn't need to have as many political appointees with prior experience, or even as many political appointees in positions. I mean, if you look at the number of vacant positions, it's remarkable. And from an administrative law standpoint, if that's your attitude, you shouldn't be surprised when you lose. Why should the administration win DACA? Very quickly, if DACA was lawful in the first place, which I believe it was lawful as an exercise of enforcement discretion. Enforcement discretion generally is not reviewable under a decision called Adler versus Cheney. There is a slight potential exception to Adler versus Cheney that lower courts think this case falls into. I think they're wrong on that point. If DACA is understood as enforcement discretion, then the Trump administration can rescind DACA just as easily as the Obama administration put it in place. But even if that's wrong, because it's not a regulation, the sort of explanation and justification that the lower courts appear to have been asking for from the administration aren't required. They would be required under the concise general statement requirement of the Administrative Procedure Act, which, as I tell my students, is typically neither concise nor general. It's usually a detailed explanation of why the agency did what it did. But for an order of this sort, there is no such requirement. And under precedents like Vermont Yankee, courts are not allowed to require such detailed explanations. Finally, the relevant test is not, was the Justice Department correct in its claim about whether DACA was lawful or unlawful. The question is whether or not it was arbitrary and capricious, i.e. it was unreasonable for them to have believed that. And given that lower courts had found that similar programs like DAPA and the DACA extension were unlawful, given that the Supreme Court appears to have split 4-4 on that question, it's certainly reasonable for the Trump administration to believe that DACA was either unlawful or would face legal jeopardy if challenged in court. And that's all that administrative law typically requires. So again, Trump administration has shown itself capable of losing completely winnable cases. But if we just apply traditional administrative law principles to the facts of that case.
Tweets help with that.
Don't let your clients tweet, even if they're the president, or especially if they're the president. This is a case the administration we would normally expect to win, and not 5-4. I mean, it's a case that I would not be surprised if it's 6-3 or 7-2.
Can I just add a couple of thoughts to that? So there's some synergy between the DACA case and the census case in the following sense that, and I assume everyone knows what DACA is protection for people who were brought here as children illegally and grew up in this country, and the Obama administration offered them protection, allowing them to stay and work and go to school because it was viewed as, by that administration, as cruel to kick them out of the only country they'd ever really known. The Trump administration came in and rescinded those protections, and the reason they gave was we think it was illegal for the Obama administration to extend them. Probably the truth is they just don't want to extend those protections, and so they don't like them when they want to take them back. And if they had just said, we don't like them and we want to take them back, I think it's pretty clear that they could do it. And so there's this, again, this question of the reason that they're giving isn't necessarily the actual reason. Because this is in other ways, this administration believes in robust executive power. And so for them to say like, oh, our hands are tied here, they really shouldn't have done it, that's why we're taking it back, doesn't necessarily ring true. And the reason they don't want to give their actual reason is because they don't want to take the political hit, because it's seen as, by many people, as cruel to kick these people out. And so they are, again, putting the squeeze on the Chief Justice a little bit and saying to him, like, you're going to be the one who has to do it, by either saying, saying we agree that the Obama administration didn't have the authority, or by saying whether they did or they didn't, it's fine for this group to pull it back.
Erwin?
Really briefly, I should disclose I'm co-counsel for the plaintiffs in one of the cases that's now before the court challenging the rescission of DACA. And I have to just disagree pretty strongly with Professor Adler here. This is about 800 to 900,000 individuals who have been told that they're going to be allowed to remain in the United States. I think what Professor Adler's analysis omits is that there is a liberty interest that's at stake here. It's a liberty interest that manifests itself in a due process, but it also manifests itself in terms of, I think the court's going to look at the administrative law issue. The only justification, as was just pointed out by the Trump administration, was that DACA was illegal when adopted by the Obama administration. But as Professor Adler says, it wasn't at all. It was an exercise of lawful discretion with regard to enforcement. Always the executive gets to choose whether to enforce laws or not. Possessing a small amount of marijuana violates the Controlled Substance Act, but the federal government doesn't enforce that. And the Obama administration said, we deport relatively few people a year of those who are undocumented. We're not going to focus on these children. And I think it's in that context that you can see why every federal court to consider the rescission of DACA, including conservative federal judges like John Bates in D.C. and liberal judges, found that what Trump did violates the APA and the Constitution. And I predict the Supreme Court's going to come to the same conclusion.
Can I just add one point here, particularly for the students here, and that is we could think about what happens on the court in terms of technical abstractions, or we could think about it as these justices as human beings that are not immune to the things that they see on television, the other things that they hear. And this is particularly in relation to the fast tracking and what connects DACA to what we see at the borders and the reports that are coming back, the images that we see of children in cages, the images that we see of a father and child drowned and face down, the images of children underneath what look like aluminum foil blankets. The justices aren't immune to seeing, to witnessing in their own regard what happens here. And if you want to think about that within the context of the court, again, just think about Brown v. Board of Education and what was happening on the ground during Jim Crow America, hoses, dogs, et cetera, and that being broadcast around the world.
Vindicating Sarah's stealing of extra time, about half of these questions are about the census, so let's spend a few more minutes on it.
I had a lot to say and a lot more.
Just to paraphrase some of the questions, will an executive order get the Trump administration around this? What's likely to happen, and when are we likely to know what's going to happen?
Yeah, if I knew the answers to those questions, I would make a lot more money than I do. I don't think, or have a lot more power at least. I don't think an executive order is going to get them out of the litigation that's already going on. There are 2 or 3 cases that are active right now, where there's one in New York and one in Maryland, where the judges have said, okay, like, we're going to hold on and wait and see what happens, but everyone agrees, and DOJ has said that they cannot put the question on without sort of telling us what's happening and giving the plaintiffs a chance to challenge whatever the new justification is. So there's this weird dynamic going on where DOJ has said, we have been instructed to come up with a new reason to do this. And it's not going to be a pretext. It's just like, that's the definition of pretext, right? You've said, like, we're going to do it.
We're literally pretext
we
right now.
We don't know why, right? Like, we're not sure why we want to do it, but we know we want to do it, and we'll let you know. So it just, and I think this goes a long way to explaining why the current team of lawyers has presumably said, we're out. Like, this is a bridge too far. The case is unusual from the beginning because the Solicitor General is going to the Supreme Court defending this obvious lie that the Voting Rights Act justification. That to me was striking even before all these other crazy things happened. I was at DOJ for 17 years, and you might expect me to say, and I saw a lot of crazy things. I saw very few crazy things. It is just not a crazy place. It's very, it is, and I was in the Civil Rights Division in the Bush administration, but even so, you see it's a very ordinary, there's regular business, it takes very seriously its institutional role with the court. And so I know there must be, I don't have any inside knowledge, but I know there must be a lot of turmoil going around this. And so I think we're going to see some filings and some arguments in the next, month. They're going to have to come up with a reason why June 30th wasn't in fact the deadline. There has been some suggestion that they could finalize the questionnaire by the end of October, but it's going to cost more money, and so they're going to have to give an explanation for why that's fine. The ACLU lawyers in the New York case have moved for sanctions for saying that, well, they've obviously been lying about the June 30th deadline. And so I think there's going to be a lot of drama to come. My bet would be we will not see this question on the questionnaire in the end.
Let me address this question first to Chris, and then we can expand it. The Supreme Court's going to wade back into the question of LGBT rights next term. Can you explain a little bit? Yeah. What are they going to look at, and how are these cases different from the kind of clash between those rights and religious liberty rights that have been asserted in the last few years in some cases?
Yeah, so the cases that the Zarda and Bostic and the funeral home case, the 3 cases, and what these cases are is Title VII of the Civil Rights Act protects against, among other things, discrimination on the basis of sex. And over the past, really over the past 9 years, there has been a growing effort to question and then eventually get inroads into the idea that within the definition of sex are contained protections on the basis of sexual orientation or gender identity, because in the case of either of those discriminations, they would not happen but for the sex of the person being discriminated against, whether it's because they are gay or whether they are transgender. And the way that these cases initially proceeded comes out of sort of the merging of 2 earlier Supreme Court cases, Price Waterhouse and On Call. And Price Waterhouse has to do with saying that sex stereotyping is discrimination. It is sex discrimination, and so is actionable. And On Call said that same-sex sexual harassment is covered, even though that might not have been what people were thinking about at that time. Justice Scalia wrote for the court that the plain word of sex obviously would cover that type of discrimination. And so what happened is that you started seeing decisions finding that discrimination against transgender people, discrimination against gay, lesbian, or bisexual people would be covered under protections against sex discrimination. And initially, this was not within one of the problems that happened is that because of Bowers versus Hardwick, that was the Supreme Court ruling that said that that basically that gay sex could be a criminal offense. It was very hard to move forward and say, oh, well, sex discrimination might allow us to make these people criminals, but you are able to be protected against discrimination in the workplace. That didn't seem right. And so there's some bad case law that was created around that. But there wasn't much case law around transgender people. And so some of these cases protecting transgender people actually happened a lot earlier than people are thinking about. There was a case out of the 11th Circuit with Vandy Beth Glenn, who was fired from her job with the Georgia Legislative Service when she announced that she was going to be transitioning. And there, it wasn't a Title VII claim, it was an equal protection claim. But the 11th Circuit, not a liberal, this wasn't the 9th Circuit, said that that was discrimination. You later saw this expand, and the Equal Employment Opportunity Commission in 2012 announced that its position was that that was discrimination. They later extended it to sexual orientation. And eventually what happened after marriage equality cases was, in my view, and as somebody who's been covering it from 2012 onward, a lot of the conservative groups decided this was their next ability to really push forward. And it was only then that you started to see arguments against it and just judges starting to really write dissents. And the dissents basically come down to two things. Either Congress hasn't passed either the Employment Non-Discrimination Act or now the Equality Act, so they've had opportunities to make these protections explicit and haven't done so, or people weren't thinking about those protections when they passed Title VII, and so they shouldn't be covered. And now those issues, both on the front of transgender people and sexual orientation, so gay, lesbian, and bisexual people, are going to be before the court. And while I think there are a lot of people who think that it's an uphill battle for the gay, lesbian, bisexual, and transgender people, it truly still is surprising to me that we can think that, because if you had looked at the cases 5 or 6 years ago, the other case was out of the Sixth Circuit. It was Jimmy Beal's case, and this wasn't controversial. It seemed like an obvious movement from Price Waterhouse and On Call to these sort of implied protections under Title VII, but there has been such an effort to push back and create another wedge issue that I think at this point it is now seen as controversial. But I still think when you get into the briefing, when you actually get into the arguments, that the clear, more straightforward position is that these protections should be included.
Jonathan, you're going to add something.
Yes, one thing that's, I think, interesting about these cases is they unsettle the way we tend to think about what types of judges like what sorts of arguments. So generally, we think of conservative justices liking very textualist arguments. Justice Scalia wrote extensively about, we care about the text that the legislature enacted. We don't care about their intention. We don't care about their purpose. We don't care what they were thinking about. We care about what's in the statute. And it's traditionally been more liberal judges who've been more interested in what's the broad purpose or the underlying intent of the legislature. In these cases, there's a very strong textual argument, which Chris hinted at, that discrimination on the basis of sex includes any situation in which, but for the sex of the individual being treated, or individual being adversely treated, they would have been treated better. And that it's very easy to see how that can prohibit discrimination against someone who's homosexual or someone who's transgender, because if their sex were different or the sex of their partner were different, then presumably they would not be subject to that discrimination. So there's a fairly traditional, we might say conservative, text-based argument for what we might think of as the liberal result. The reverse is true as well. If we want to focus on what was the mischief that the Congress that enacted Title VII was focused on, it's pretty clear, and there's ample evidence of this, that at the time, Congress did not view sex and sexual orientation as the same thing, but as rather distinct categories. That legislatures repeatedly at both the federal and state level have treated sex and sexual orientation as separate categories for the purposes of anti-discrimination law. And so if one applies the sort of intent-based or purpose-based analysis we often associate with liberal judges, you ironically come up with what we might characterize as the conservative result. And so one of the things that I think will be really interesting to see in this case is how the justices deal with the fact that the outcome we might think they might prefer as a policy matter and the outcome that their traditional interpretive approach might lead them to might be at cross purposes. And in some of the lower courts that have split on this issue, we've seen this kind of underneath the surface. So for example, Frank Easterbrook, a very textualist judge on the U.S. Court of Appeals for the Seventh Circuit, joins the Seventh Circuit opinion saying that sexual orientation discrimination is covered, and a judge who I'm forgetting now on the Second Circuit, who's not particularly conservative, wrote an opinion on the other way when the Second Circuit heard this case. So that's something to pay attention to when the court hears
Let
this.
me just add here that Kavanaugh is no Kennedy. And what's missing from the court in the evaluation of these cases is a Justice Kennedy, who was the pioneer on the court of recognizing, pushing forward, writing the opinion in cases that evolved the court's thinking with regard to LGBTQ issues. He's no longer there. So this really begs the question, what's the ideology of Kavanaugh or of a Gorsuch? Is there confidence that one will step in and be the Kennedy? Will Kavanaugh be the Kennedy? And my sense is that it's a bit doubtful. It may be that we find ourselves in a retrenchment of LGBTQ equality, somewhat in the same ways that we've seen with the challenge of issues involving racial equality and even sex equality. So I'm a little bit more skeptical than my colleagues right here.
I want to agree with Michele and point to something that happened this term. 3 federal district courts issued preliminary injunctions against President Trump's ban on transgender individuals serving in the military. President Obama had issued an executive order allowing it. President Trump rescinded it, banning transgender individuals. The Supreme Court took the unusual step of lifting those preliminary injunctions without waiting for any Court of Appeals decisions. Now, a preliminary injunction should only be returned for abuse of discretion. Nonetheless, the 5 conservative justices all said that the preliminary injunction be lifted, the transgender military ban should be able to go into effect. The 4 liberal justices vehemently dissenting to that. I think that may very well be an indication with regard to sexual orientation, and it goes with what Michele was just saying. The majority opinion in every Supreme Court decision in history expanding rights for gays and lesbians was written by Anthony Kennedy, and he's no longer there.
We only have a few minutes left.
Tag team,
yes.
Erwin, Michele.
I'll respond on Twitter later. I have thoughts on both of those, but I'll let us go to the next question.
This will be the last question because we're almost out of time. I'd like you each to reflect on this. I'll read this card, but then I want to add to it. The card reads, popular sentiment always speaks of the, quote, conservative bloc, yet the 4 liberal justices seem to vote as a bloc more often. Please comment. And let me just expand this and ask this question more broadly. We're now at the first time in at least modern Supreme Court history where all of the conservative justices have been appointed by presidents of one party, and all the liberals have been appointed by presidents of the other party. What does this mean for the long-term legitimacy of the court, and what kind of pressure is that going to put on the court? And why don't we work our way down the line?
So, I think the question does point to something that is interesting that we've seen over the last several terms, which is the conservative justices write separately to disagree with each other on small points of doctrine, even when they agree on the result, far more often than the liberal justices do. A few terms ago, it was interesting that when you looked at cases like King versus Burwell and Obergefell and so on, you had a case after major case where every opinion on both sides was written by a conservative justice. Creating impression, I think, is fair that the liberal justices, who might see themselves as playing defense, right, since they are the minority in the court, feel it's more important to stick together rather than to disagree with each other on precise issues, and that when they win, again, not to confuse things. So Justice Ginsburg made a comment after Obergefell indicating that the opinion Justice Kennedy wrote was not the opinion she would have written. But if Justice Kennedy was going to write that and get that result, that's, we can deal with the doctrine in the future. And so I think one thing that we need to watch going forward is whether or not the conservative bloc remains as a bloc. Again, they are writing separate opinions a lot of the time. Justice Kavanaugh and Justice Gorsuch only agreed 70% of the time, which is not a lot. We regularly see pairs of justices, especially when they are appointed by the same president, routinely 90% agreement per term. To see two justices appointed a year apart by the same president disagreeing 30% of the time is remarkable. And seeing the number of 5-4 decisions, which I think Erwin mentioned before, where one of the conservative justices broke ranks to join the liberal justices is notable. It's too soon, I think, to know precisely what it's going to mean going forward, but it is something worth paying attention to, and I think it's a healthy thing. It's something that we'd like to see. I certainly would like to see more of. A little bit less predictability, a little bit less of justices operating like they're part of a phalanx, and being willing to be more independent when they think their usual allies have gone astray. So hopefully we'll see more of that.
All right, Rick, I'm tearing up because I don't want this to end. It's not because of my coughing up here. I think this is a very interesting time to see Justice Roberts come into his own. He's already articulated there are no such things as Trump justices, as Obama justices, et cetera. And I think the legitimacy of the Supreme Court is really at stake, including his concern about what legacy he will leave behind. Now, some people say that that's overstated because he, too, will still want to vote with the conservative bloc. But I think in many ways we've seen that Roberts wants to be somewhat nuanced, particularly given this administration. When you ask about the liberal justices, though, there's a real question as to whether or not they have their own sense of plotting. One might call it a jurisprudence in exile, and that is setting the tone for the time in which there will be a different day on the court. It flags an important question for us, and one that you've written about and one that Erwin has written about, and that is, should there be term limits of the justices? Erwin has also talked about and received some real backlash when he said that Breyer and Ginsburg should retire years ago.
Not now, he's not saying that.
Oh, not now. Right now, we all want to be kidney suppliers, give blood, and whatever we can possibly do to keep them on the court. Right? But it does raise some very significant questions about how they try to hold the course, and maybe, Justice Ginsburg thought at the time when many, or at least Erwin, suggesting that, look, there should be a transition on the court for someone dynamic and younger to get on the bench, that her dissents could mean something at a different time, although one might say, what's the value of being in the dissenting party?
Yeah, I think that echoing off of what Jonathan said, I think that split between Gorsuch and Kavanaugh is really interesting, and I think it sort of represents in some ways two aspects of the Republican Party. I think we are seeing sort of some real libertarian realities out of Gorsuch's opinions, particularly on criminal law. And I think that could make a big difference going forward. And Whereas I don't think we really have a good idea of what a Justice Kavanaugh is yet.
We don't?
I mean, despite we might know too much. But I think that this term, I think there's a lot of evidence that he was trying to decrease his profile after a much higher profile than he had expected to have. And so I do think that we should be careful not to read too much into what he's doing this term, or probably even next term, although I don't think he's going to be able to get away with it as much next term because of some of the cases that are coming up and the likelihood of 5-4 decisions on them. But I do think, I mean, with the, I don't think I think we've seen a willingness from a lot of the center of the court to play around with their roles, given the new reality. And I think that that's sort of a freedom that you have when you're a 5-4 conservative majority, but it also leads to some unexpected outcomes. And I think we're seeing that with the Chief Justice, with Gorsuch and Kavanaugh, but also with Justice Breyer. And I think that we really could see ourselves, although I think Gorsuch is more conservative, I think we could see ourselves sort of in a 3-3-3 pairing next term a lot more than we're used to.
Sarah?
Yeah, so just a couple thoughts. I do think the more liberal justices, they are voting as a bloc quite often, and I think that just reflects their defensive posture. Their strategy, I think, is to write reasonable and narrow opinions in the hopes of luring over a fifth vote. And also, I think they see their role, or at least some of them do, as sort of calling out hypocrisy or dishonesty in the majority bloc when they see it, as a way of kind of putting pressure on those who are concerned about the legitimacy of the court and its public perception. I do think, the sort of general view going into this new court was that the Chief Justice is going to be the swing vote, and I think that we see potential for Gorsuch and Kavanaugh and Roberts all to kind of swing depending on the topic. One area that hasn't gotten a ton of attention is the criminal justice docket outside of the death penalty context. There has been a real swing, gradual but real, towards criminal defendants, at least in federal criminal cases, where people like the Chief Justice and Justice Gorsuch, who has sort of a libertarian streak, view federal enforcement of federal law as too aggressive in recent years. And so you have seen a real movement towards more rulings in favor of criminal defendants. And in fact, Justice Gorsuch sided with the 4 liberals in at least 2 cases ruling for criminal defendants. And so I think, that's a little bit of a surprising development, and we may hopefully see more of that.
Erwin?
Aggregate data, especially aggregate data from just one term, can be very misleading. Think about the issues that were before the justice this term, where ideology was likely to predict: death penalty, partisan gerrymandering, sovereign immunity case that I argued and lost. All of them were 5-4 split along ideological lines. There was a major case about property rights, 5-4 split along ideological lines. I think when the court gets to issues like abortion, affirmative action, gay and lesbian rights, we're going to see the 5-4 split, even though it may not be manifest in every area that the court deals with. I think Rick puts his finger on something very important in terms of what does this all mean for the long-term legitimacy of the court? What's the long-term effect of the Kavanaugh hearings that so deeply divided the country and created the closest margin for confirmation ever in United States history? What's the effect of the blocking of Merrick Garland in an unprecedented way in American history that caused a significant number of people to believe there was a stolen seat on the Supreme Court? What will it mean in a context where our country is as politically divided and polarized as ever? What will legitimacy of the court mean at a time when the legitimacy of the other institutions of government, the president and Congress, are at all-time lows? I think this is such an enormously important question, and one that none of us can answer at this point in time.
Well, this has been
There's an ending.
It's been an extraordinarily illuminating discussion and really does make me look forward to next year's 10th annual Supreme Court Term Review. Please join me in thanking our panelists. We'll see you next year.